Hi, this is Shay Dougall from Australia, and Benedict, do you want to unmute yourself?
Unmuted. Hello, I'm Benedict from Australia.
And Marianne Lloyd-Smith.
Hi, it's Marianne from Australia.
And Dr. Geraldine McCarran.
Hello, I'm Geraldine McCarran.
So thank you very much for this opportunity. What I thought I might do is just go straight into some introductions. Can you see the screen there? Okay, my name is Shay Dougall. I'm a wife, a mother, an OHSE professional, a landholder advocate and a gas field resident, and the convener of the Australian Tribunal. Benedict is a member of the Australian Lawyers for Human Rights. He's also the chair of the Human Rights Act committee. And Benedict is a well qualified and well-respected human rights lawyer in Australia who's got an enormous amount of experience. Dr. Geraldine McCarran is a GP who practices in Brisbane. She has spent lots of years on the ground out here in the gas field, is very well respected by the people out here, and is in a very unique position among her peers. And Dr. Marianne Lloyd-Smith, again, eminently qualified doctor who is expert in toxicology and who has given evidence all over the world, and she will be talking about the toxics of the unconventional gas. Our overview is the session is basically, I will give a brief introduction, Benedict will then undertake his part, Dr. Geraldine McCarran will talk about health, Dr. Marianne Lloyd-Smith will talk about the topic, and then I will continue to complete the process of our other sessions, and then Benedict will summarise our session. We'll have some time for questions at the end. So basically, unconventional gas in Australia, well, it's big business. How big? Well, let's have a look at just how big it is. I'll show you this interesting slide. So this is an interesting slide, and this will show you just how big the business is in Australia. So that's a map of Australia, obviously. This is the oil and gas tenements across our country. And this is the oil and gas wells that are currently drilled in our country. And you can see where the tenements are, where we're expecting it to be drilled in the future. And this is the gas pipelines across the country. So yes, gas is certainly very big business in Australia. As elected representatives of the people, the government also has a contract with us, and that contract though has limited rights. So when the government is pursuing the gas, our contract with them only requires them to consider limited rights with regard to us, the people, but they maximise the rights of the industry, and this is what is resulting in the impacts. The thing is that way back in 1932, a pair of academics may well have been prophetic when they theorised that the corporation as an economic organism may even supersede the state as a dominant form of social organisation. Well, in my current experience advocating for landholders impacted by unconventional gas, it is clear to me that the line between the government and the multinational companies is not only blurred, but in some cases it's non-existent. So basically, us, the landholders, are the trade-off in the government's dash for gas and cash. In the pursuit of the dollars and getting the gas out of the ground, the government and the industry is trading off what they see is short-term impacts on landholders for their own shareholders' value. But the reality is that this is where they are mistaken, because there are long-term impacts that they're not factoring in, but it will cost them and it will cost us. They're not what they are actually doing is managing for gas shareholders, and they're forgetting about the other stakeholders, who are us. So our contribution to this tribunal highlights those failures to govern for us, the stakeholders, and the rights that our limited contract with the government fails to address. Our evidence is hosted at that web address. We've written a report that summarises our evidence and submitted that to the tribunal. And that report maps our evidence against John Knox's 2018 report and applies that to the 5 subcases that we provide evidence for. So in considering the evidence that we've provided and given the 20 to 40 years impact ahead of us in this existing industry, those impacts that are still to occur, and this industry that's rapidly expanding, we're asking the judges to consider the potential future harm as well as the harm committed today. And our contribution to this tribunal is a cry from thousands of real individuals who are pleading for you to help us make our government start governing for stakeholders and not gas shareholders. So I'd like to introduce you to the next speaker, who is Benedict Coyne, and I will just unshare my screen so Benedict can take over. I think I've done that. Benedict, over to you.
Thank you, Shay. Good morning, everyone. Tribunal members, for the record, my name is Benedict Coyne. I am Executive Counsel at a Queensland law firm and the immediate past National President of Australian Lawyers for Human Rights, which is a national association of legal professionals who advocate on the promotion and protection of international human rights standards in Australia and overseas. I stepped off 2 weeks ago after being 2 years in the National President position, and I am now remain on the Executive Management Committee and the Chair of the Human Rights Act Subcommittee, which will become relevant later in my submissions. I appear today on behalf of the Australian subcases and to provide submissions to assist the Tribunal in relation to this petition and in relation to its considerations and deliberations of the Australian Government's obligations under international human rights law as they relate to the impugned conduct and activities of the unconventional oil and gas extraction industry, which I will collectively refer to as the fracking industry, in both Queensland and Australia. I thank the Tribunal members and the Permanent Peoples Tribunal and all of the organisers, specifically Tom, Anna, Damien and Carly and everyone else, and all the contributors, the lead attorneys, Shay, especially for organising everything at this end. And I thank everyone for this exciting and worldly opportunity to present to the Tribunal through open, accessible forum of digital media on these very important human rights environmental issues at a crucial time where humanity finds itself precariously perched upon the precipice of irreversible, catastrophic climate change. I would like to pay my respects to the traditional custodians of the land on which I am today, which is beautiful, sunny, albeit wintry Brisbane, and they are the Jagger and Turrbal people. I pay respects to their elders past and present and emerging, their ancestors and their future generations. And I would also like to acknowledge that I speak today on stolen land, that sovereignty was never ceded, neither by Aboriginal Australians nor Torres Strait Islanders. I would further like to acknowledge the traditional Indigenous custodians of the land on which everyone listening resides around the world, their elders past and present, emerging, and ancestors. And finally, I would like all of us to acknowledge our future generations, our children's children's children and so on, the plants, animals, water bodies and ecosystems on whose behalf we engage in this important work. In the words of the Special Rapporteur on the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy and sustainable environment, John Knox, who said, quote, "Human rights and environmental protection are interdependent. A safe, clean, healthy and sustainable environment is necessary for the full enjoyment of human rights, including the rights to life, to the highest attainable standard of physical and mental health, to an adequate standard of living, to adequate food, to safe drinking water and sanitation, to housing, participation in cultural life and to development, as well as the right to a healthy environment itself, which is recognised in regional agreements and most national constitutions in 2018. At the same time, the exercise of human rights, including rights to freedom of expression and association, to education and information, to participation in the effective remedies, is vital to the protection of the environment, and I would add, to the protection of our democracies. The global frontier of fracking and fracking industry. Sorry, I'll start that again. The global frontier of the fracking industry brings high crisis for international human rights law, for democracy, and for the rule of law. However, the raging expansion of this dirty, dangerous, and toxic industry also presents opportunities for change. We know well the evidence of some 270,000 wells that have been fracked across North America and the world, and hundreds of incursions of human rights violations by large corporations throughout Australia, which will become the subject of detailed evidence to this tribunal. In terms of giving a bit of an overview of where Australia is at, it is worth noting that in Queensland there is unrestricted access for fracking companies, whereas Victoria became the first state to permanently ban fracking last year. There are moratoriums in Tasmania and West Australia, and New South Wales has applied certain restrictions. The new South Australian Liberal Conservative government is planning a 10-year ban on fracking in much of the state's southeast. However, the Northern Territory recently announced on the 17th of April that its ban on fracking will be lifted, much to the caution and terror, perhaps, of Northern Territorians who know what's been happening in Queensland. The federal government is also pushing for more fracking. Federal Minister for Environment and Energy, Josh Frydenberg, recently stating, quote, "I would like all moratoriums and bans across Australia lifted because more gas is good for jobs and it's good for energy security and supply." And thus we meet here today, and the work of the tribunal is incredibly important. So fracking presents high pressure politics in Australia, and if the highly disruptive fracking boom precedents in the US and Queensland are anything to go by and expanded, there is much at stake, including the very integrity of our democracy. Beyond its proven devastating toxic environmental effects, being the dire water, land, air, and climate change causing contamination, this most controversial industrial activity of our time is an unprecedented global threat to the intertwined complex of universal human rights. Humans, I guess I would state very obviously, require a healthy environment for a fulfilling and dignified life, for the ability to achieve self-realization, self-determination, and community harmony. Fracking engages the profiteering might of the industrial military complex. Companies such as Halliburton, whose conduct from the US to Australia is rupturing the very socio-cultural fabric of our democratic socio-cultural commons, the collective good, and a place that we like to call home. Historic boundaries delineated by law have been uprooted and challenged by the dash to frack. It has exposed the profound frailties of our political institutions, meant to regulate industry, protect human health and environment, and as our opening session exclaimed, the state is meant to be the guarantor and protector of our human rights. However, that is certainly not the case in Australia. Fracking signifies the tragedy and promise of the dusk of an era, a last-ditch rapacious land rush of a plummeting, and I would submit fossil foolish paradigm in its last desperate clutch for power. Political power, energy policy power, private profit power, and power itself. Yet, of course, the counter, people power and human rights, are still relevant in the mix, certainly in Australia and around the world, and may indeed yet surmount the Goliathan, gargantuan corporate gas interests and just make it through to the finish line of protecting all of our rights, albeit gasping for breath. The aforementioned moratoriums throughout Australia and the determined work of civil society groups, in particular people like Shay, Geraldine, John Jenkin and his family, and the over 40,000 person strong Lock the Gate Alliance, which is landholders committed to engaging their fundamental democratic rights to commit civil disobedience if necessary, to refusing access to private fracking companies to their private property, and in that way to prevent them from violating their human rights. All of that represents the hope, whereas the abhorrent, destructive, scorched earth examples in Queensland of an unrestrained, rapacious fracking industry, and governments selling out such policy represent the horror and the danger. Therefore, there is much at stake, which is why this petition to the Permanent Peoples Tribunal is of such crucial importance. I will now be focusing on my area of specialty, being human rights law and international human rights law in Australia, and outlining for the tribunal the answer to the question of why things in Queensland in particular, and Australia more generally, are so democratically dysfunctional to have allowed the rapid expansions of a rights-violating industry. And I think that the answer and exploration of that question is instructive, as history always is, to be informing our mapping of how we take steps into the future, and the recommendations and advisory opinions that this tribunal may make that will assist all of us in trying to plot a path to a much more safe, sane and sustainable future. So in order to answer the question, it is necessary to traverse the history of human rights in Australia and outline the motivations and mechanisms of its ongoing international human rights law recalcitrance. Conceptualizations of human rights have existed for many centuries, namely in the threaded theatres of the world's theologies and sacred spiritual teachings weaving through the winds of time. Human rights are ancient concepts imbued in the world's major religions. Principles of mutual respect, tolerance, compassion and dignity are a core part of Christianity, Islam, Buddhism, Hinduism, Judaism, and hopefully even Pokemon Go, and so on. Another historic source of human rights is, of course, the common law rules and principles established by judges on a case-by-case basis throughout the centuries. And when Australia was invaded, the common law was imported into this land. Of course, the world's first Bill of Rights, the Magna Carta, is probably the most famous founding human rights document, which then influenced various declarations, revolutions in America, in France, and all of those developments and evolutions informed the creation of the modern conceptualization of international human rights law through the formation of the United Nations. It's also important to mention that all of the international treaties emanating from the United Nations and the 7 core international human rights treaties, which Australia has signed and ratified, are all predicated on what I would call the international consensus of good faith participation in the international, modern international order. And that comes by Article 26 of the 1969 Vienna Convention on the Law of Treaties, which stipulates the principle of pacta sunt servanda. And that is, every country who ratifies an international treaty must do so in good faith, that it will uphold the principles and laws therein, including via the domestic implementation of those principles and law. And I would suggest that this is colloquially the handshake of humankind that allows for the efficacy of international law, which is arguably the cornerstone of our civilization. And without those good faith obligations being realised, and without those good faith obligations being respected, we are all in a much more precarious place as a global order. It's a very delicate handshake. Human rights came into their own in an official, universal and international legal context as a fierce phoenix arising from the Holocaust horrors of World War II and revelations of an abhorrent widespread genocide. The preamble of the Universal Declaration of Human Rights expounds, quote, "Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech, belief, freedom from fear and want has been proclaimed as the highest aspiration of the common people." And all of that is applicable and transferable to the predicament in which we find ourselves regarding corporate and state violations of human rights in an environmental context, especially because we're facing such a global catastrophic situation with emissions causing climate change, etc. So Australia's history in this whole process is quite remarkable, given we're such a, I guess, small nation relatively and according to population, in the sense that Australia was instrumental in the drafting of the Universal Declaration of Human Rights. In fact, we had one of the 8-member drafting party. That drafting party was chaired and supervised by Eleanor Roosevelt, and it basically formulated a blueprint for an architecture of dignity, tolerance, and inclusive plurality amongst the multiracial, multi-ethnic, multicultural, multi-political, multi-sex, multi-gender, multi-ability, multi-indigenous, kaleidoscopic expressions of humanity. And our delegate, Australia's delegate there, Colonel Roy William Hodgson, was a survivor of the Anzac Gallipoli historical moment and incident in the First World War, and he went on to become an international diplomat. At the same time, Australia did also have a foreign minister who became the 3rd president of the UN General Assembly and oversaw the adoption of the Universal Declaration of Human Rights on the 10th of December 1948. We have the 70th anniversary this year. And I say all of that because I believe very strongly that Australia bears a significant responsibility in upholding that delicate handshake of which I spoke. We are now on the UN Human Rights Council from the 1st of January this year. We were elected in October last year, and yet we are absolutely have a very deplorable and despicable record in terms of failing to uphold our obligations to the international community. And I spend a lot of my time drawing those contrasts and distinctions and highlighting them as well, and also paving a positive way in which we can easily rectify those, those issues. So I think that also it's worth pointing out the competitive false dichotomies around conservative ideas of what human rights are or are not, or who they belong to and whom they do not. There appears to be a profound misconception, especially these days, of rising neoliberalism, nationalism, militarism, and anti-rights groups, that human rights are somehow a finite resource, whereas actually the fountain of human rights is an infinite spring. It flows freely for everyone by virtue of the fact of being human. And a meme I saw the other day on Instagram, and seeing we're on digital media, I thought I might cite it, which said, quote, "Equal rights for others does not mean less rights for you. It's not pie." So I might jump forward, just noting time. Now, Australia unfortunately holds the enviable position of being the only Western liberal democracy and common law legal system without a Bill of Rights or any Human Rights Act. We have had 4 decades now of UN treaty bodies, special rapporteurs, UN heads of UN member states recommending that Australia implement its outstanding international obligations by way of a Human Rights Act or an international Bill of Rights. And all of those calls have gone ignored. Unfortunately, when the constitutional framers were meeting in the 1890s, they had a number of conventions, and they were very enamoured with the American model of constitutional law, but also felt a loyalty to the United Kingdom and the way that was constituted. So they kind of borrowed from both. But whilst there were a number of advocates for a Bill of Rights, it was rejected because it was considered that rights protections like due process at law may interfere with laws made to the detriment of racial minorities, including immigration laws and those laws prohibiting Chinese people from working on the goldfields. So it started out as a racially discriminatory motivation to not have a Bill of Rights, and our constitution, very sadly, remains one of the only liberal democracies with an actively racist constitution that does not hold any stipulations or protections even for basic equality, which is absolutely remarkable in this day and age. As international human rights law expert Professor Ben Saul put it, quote, "A Bill of Rights was rejected during the drafting of the Constitution because it was said that elected parliaments would never violate rights as long as you were white." Now, Australia, as I said, is a signatory and has ratified the 7 core international human rights treaties, being the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, both of 1966, and we signed that on the 10th of December 1972, and they were ratified in the subsequent years. We've also ratified the 1963 International Convention on the Elimination of All Forms of Racial Discrimination, the 1984 Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, the 1981 Convention on the Elimination of All Forms of Discrimination Against Women, the 1989 Convention on the Rights of the Child, and the 2006 Convention on the Rights of Persons with Disabilities. As I stated before, since our first periodic report, and this all became very live and illustrated during our first Universal Periodic Review in January 2011, and also the second Universal Periodic Review in November 2015, that Australia's had, as I said, 4 decades of UN bodies basically saying, why haven't you properly implemented your outstanding international obligations? So I'm going to jump forward a little bit again and just talk about our special rapporteurs with regards to Australia have criticised Australia's lack of constitutional and legislative human rights enforcement mechanisms as follows. We, in 2000, and this is just a non-exhaustive list of examples. In 2006, we had the report of the Special Rapporteur on Human Rights Compliance while Countering Terrorism, again recommending Australia's ongoing failure of domestic implementation remains a significant concern of the Human Rights Committee. And the Special Rapporteur urged Australia to enact federal legislation implementing the ICCPR. So we haven't even complied with implementing the ICCPR, which is, I would suggest, significantly embarrassing for a country who now and advocated so fiercely to be on the United Nations Human Rights Council. 2007, the Special Rapporteur on Adequate Housing said the same thing. 2009, the former UN Special Rapporteur on Indigenous People, James Anaya, visited remote Indigenous communities and also found Australian breach, and those remote Indigenous communities are affected by fracking directly. Former Prime Minister Tony Abbott's response then, and this is symbolic of Australia's general demeanour when it comes to selective aspects of the international order, was, quote, "This is the kind of nonsense we're used to from these armchair critics. I think he should get a life." I think factually and objectively, James and I probably visited more Indigenous communities than Tony Abbott ever did. 2010, the Special Rapporteur on Health recommended Australia constitutionally enshrine rights encompassed in all of those outstanding treaties and make them directly justiciable. And March 2015, the Special Rapporteur on Torture found Australia in breach of the Torture Convention, which was absolutely unprecedented, and that was due to Australia's treatment of asylum seekers in offshore detention centres, Nauru and Manus Island. November 2016, the Special Rapporteur on the Rights of Migrants also found similarly and recommended a federal human rights framework be implemented post-haste. And the Special Rapporteur on Violence Against Women in March last year. In April last year, the UN Special Rapporteur on the Rights of Indigenous People, Victoria Taulu-Corpus, also made similar and broader criticisms, specifically with regards to the rights on Indigenous peoples. And then earlier this year, 2018, the report of the Special Rapporteur on the situation of human rights defenders, and that is the French jurist Michel Forst. Now, I had a number of clients who were had cases against the fracking industry and fracking companies in particular, and we were doing advocacy on that. And quite a large number of environmental advocates and community advocates like Shay, like Geraldine, met with Michel Forst to talk about the significant problems. So I'm going to jump right ahead and kind of finish up now, basically just talking about the rapid expansion of fracking has unfortunately manifested as the headstone of democracy and a logical progression of unrestrained corporate power, a systemic invocation of government against its people. And it violates numerous universally accepted human rights as contained in all of those treaties, including the right to life, Article 6 of the ICCPR, Article 6 of the Declaration of Human Rights, the right to the enjoyment of the highest attainable standard of physical and mental health, Article 12 of ICESCA and Article 12 of the Declaration of Human Rights. the new emerging right to a healthy environment, which finds its place in the January 2018 framework principles that have been formulated, framework principles on human rights and the environment formulated by the former Special Rapporteur on the Environment, John Knox. But we also need to think about perhaps less direct violations, including the right to an effective legal remedy, Article 8 of the Declaration of Human Rights, the right to not be arbitrarily deprived of property, Article 17 of the Declaration, the right to self-determination finds itself in all of those instruments, the right to equal protection of the law, the right for Indigenous peoples to enjoy their own culture, and the Declaration of the Rights of Indigenous Peoples becomes important there. The right to safe and healthy working conditions, talking about workers, the right to an adequate standard of living, including adequate housing, the right to legal protection against arbitrary and unlawful interference with privacy, family and home, the right to equal access to the public service, Article 25 of the ICCPR. And also, it's very important, and I'm sure there will be focus on it, and I've seen it in the submissions, the 2011 Guiding Principles on Business and Human Rights are rapidly emerging as being a substratum formulation of acceptable standards that through the behaviour of non-state actors like corporations are becoming more and more accepted as the standards by which corporations should operate. And in fact, the framework principles, which I'll talk to in my next presentation, endorse and encourage and embody and apply those standards. I think I have gone over my time. I'm pretty much at the end, and I just wanted to finish off and sorry, talking about the Guiding Principles on Business and Human Rights, particularly Guiding Principle 25, which stipulates as part of their duty to protect against business-related human rights abuse, states must take appropriate steps to ensure through judicial, administrative, legislative and other appropriate means that when such abuses occur within their territory and or jurisdictions, those affected have access to an effective remedy. And that is what we need urgently in Queensland and in Australia. I think I might leave it there, but all of what I've said will inform our recommendations to the tribunal in its considerations and deliberations on this petition. Thank you very much.
Thank you very much for that, Benedict. Thank you. What we will do now is start our first presentation on the subcase of health. I'll just start that presentation now, share my screen and give Geraldine control. So just bear with me for 1 minute. Okay, so in our first subcase, it is about health, and I would like to introduce Dr. Geraldine McCarran, who will be taking this subcase. Geraldine, over to you.
Hello, my name is Geraldine McCarran. I'm a doctor who works in Brisbane. I would like to talk about the subcase of health. Health, as we know, is a state of complete physical, mental and social well-being, and not merely the absence of disease or infirmity. And the basic requirements for physical good health are clean air, clean water and adequate supply of uncontaminated nutritious food. But physical requirements are not enough. To be healthy, one needs mental and social well-being. Through all the subcases, the impact of the gas industry on the health of vulnerable groups is apparent. As far back as 2008, in the exploratory phase, physical health impacts have been reported to health authorities and government agencies. And these physical health impacts included nosebleeds, eye irritation, skin irritation, rashes, headaches, nausea, metallic taste, chest tightness, cough, muscle spasms, severe fatigue, weakness, pins and needles, and these were happening even in small children. At the expense of their own health, Australians have spent years embedded in the struggle to protect the land they love for the well-being of generations to come. Some have likened their experience to post-traumatic stress disorder, but the trauma goes on. And for the first peoples of this country, whose connection to country and their responsibility for protecting it is an intrinsic part of who they are, the invasion by the gas industry is devastating. In this framework, in terms of what I would like to do, I would like to frame the issue of health in in terms of Principle 2, the Australian government has failed to respect, protect and fulfil human rights in order to ensure a clean, safe, healthy and sustainable environment. The means they used to do this was through a culture of no data, no problem. The unconventional gas industry has been allowed rapid, unprecedented expansion into Queensland with little regard for the public health consequences. Industry and government failed to establish baselines. Communities have continuously raised concerns regarding impacts on health, both direct and indirect. Public health concerns have been trivialised and ignored by government and industry, and to date, no formal comprehensive health study has been undertaken to determine impacts of the industry. But despite the lack of specific official data, the residents who live with it know and can demonstrate the impact of the fossil fuel industry. I'd just like to look at this timeline. By 2010, complaints of ill health by 2010, complaints of ill health in the heart of the emerging industry were gaining traction in the media. Finally, in 2013, the Queensland government produced the only publicly available assessment of health impacts of coal seam gas, which was commissioned by the state. In the same year, I produced a report documenting the health complaints and critiquing the Queensland's really inadequate report and recommending action. By 2016, Morgan et al. Had recognised the mental health impacts and published research indicating coal seam gas concerns were a significant contributor to psychological morbidity. In 2017, Werner et al. Documented increased hospital admission rates for neoplasms, that's cancers, and blood immune diseases in coal seam gas areas compared to other study areas in Queensland. And then earlier this year, I published a paper using gas industry acknowledged emissions and Queensland's health own data of hospitalisation to indicate that there is very possibly a very large public health issue. And then in 2018, also this year, Claudio et al. Published a paper looking very closely at the 2013 Queensland Government report, the one that is really important to understand, that Queensland Government report from 2013 had one very important recommendation. That recommendation was to monitor total gas field emissions and the exposure of the community to those emissions. And it's important to understand in that 2013 report that not only did the government fail to follow up on that Queensland health recommendation, but that regulator actively blocked that recommendation. So in 2018, Claudio et al. Published a paper looking at the Queensland Government 2013 report from the point of view of international best practice health impact assessment methodologies. And what they found was that it failed to meet these international best practice because 7 out of 9 key steps were omitted. Also in 2018, this year, JASERA, which is a government and industry funded research body, they undertook a project to review the state of knowledge about health impacts of coal seam gas, identify the gaps and develop a framework that could be used to design a study. And this report, now this year, 13 years after the start of the industry, acknowledges that an in-depth health impact study has yet to be conducted in Australia. A coordinated database of chemicals used by the Australian coal seam gas industry is not available, and inventories of emissions resulting from the extraction process, such as VOCs, norms, metals, and salts, are also not available, and access to the data owned by industry is restricted. The problem then is, what's the difference between alternative truths and straight lies? The significance of the evidence on the timeline is that on the basis of their totally inadequate 2013 report, the government actively promoted the outright lie that they had comprehensively investigated the health complaints. And on the back of that lie, they promoted massive expansion of the coal seam gas industry in Queensland. The expansion of the coal seam gas industry includes into Hopeland, which is beautiful, productive agricultural land, which has been the site of yet another type of unconventional gas exploration. And it has been the site of serious environmental harm caused by Link Energy's underground coal gasification. And for years, local people have been reporting serious environmental and health harms to people and to the domestic animal. Just last week, Link Energy was fined a record for Australia, $4.5 million, with Judge Shanahan saying that the offending was carried out over 7 years and was persistent and in clear breach of its obligation. But one might ask, what on earth are the regulators doing for 7 years? The government itself was a partner at the beginning of this project. And although Link Energy has been fined $4.5 million, no compensation and no rehabilitation is proposed for the landholders in the extensive area of environmental contamination. Instead, the government, ignoring all pleas to the country, has given coal seam gas companies permission to drill hundreds of gas wells into the same coal seam through the contaminated land under Hopeland. It's not just failure, it's willful failure. The government has ignored all evidence on coal seam gas and underground gasification. They also have willfully ignored the industry's contribution to the health impacts of climate change. They have also actively supported industry participation in shale gas development. And they did this despite, as we know, the mounting international evidence of serious adverse health impacts, which includes increased hospitalization for asthma, cardiac, neurological, and skin conditions, increased incidence of congenital heart defects, increased childhood leukemia, low birth weight, and early infant death. Our government has failed to protect our human right to health. There's been a failure of the government to identify the health risks. There's been a failure to assess the health risks in association with impacts on the environment. There's been a failure to properly assess the environmental impact and therefore to integrate the environmental assessment with the well-known associated health risks. There's been a failure to monitor and to measure the impact on health risks. There's been a failure to protect people when people have raised concerns with the government regarding the experience of health risks. But the health risks are known. From the gas fields, the residents themselves can identify the impacts. And so I'd like to hand you back to Shay, who will show you some visuals.
Thank you very much, Geraldine. I appreciate that. I thought I'd start by showing a map of Australia with an insert of the shape and size of the state of Oregon. And just to give you some comparison to the next image, which is broadly the same sort of size and shape as the state of Oregon in the state of Queensland. This is our community here. This is where I live. This is a vision from Google Earth, and you can see my community of Chinchilla here. And what you can see there is coloured in red is actually the land that is now owned by coal seam gas companies. If we zoom in just a little bit tighter, this is a little bit closer view of people's properties, our homes, our community, state forest, and also a bit closer view of how much of the land is owned by the coal seam gas industries, no longer owned by individuals, mothers and fathers and farmers. That is an image of all of the wells that have been drilled into our community to date and overlapping the homes and the backyards of families. And that you can see scattered through there is a few little red dots that show the acknowledged industry contributions to the atmospheric emissions and the atmospheric toxins that are produced by the industry. They're called the National Pollutant Inventory sources. And this is what the industry admits and acknowledges that they're producing, and this is just in 1 year, as emissions into the atmosphere in that particular community there. Now this is an even closer image of just one family's home, that black star there, and a 2-kilometre radius of their home, certainly the wells, but the wells aren't shown in this image. What is shown in this image is the points of emission that are coming from those infrastructure from the industry, but are not accounted for in any of the National Pollutant Inventory data. And this is what we see when we use a FLIR camera, a forward-looking infrared camera, to identify these emissions that aren't being counted, that can't be seen with the naked eye. But when you look through a FLIR camera, you can see the volumes of gas that has been emitted in a manner that is not monitored, not measured, not mitigated, and certainly not recorded. And when we do our own testing of those emissions that we just showed you footage of, this is what we find is coming out of those points of emission. So what I'd like to do is now introduce you to our next speaker, which is Dr. Marian Lloyd-Smith, who's going to address the issues of the toxics associated with unconventional gas and the human rights impact. So I'll stop sharing my screen and introduce you to Dr. Marian Lloyd-Smith.
Good morning, and thank you for this opportunity to add to what you have already heard from the National Toxics Network in our testimonies and written submissions which have been provided to you. This time, however, I'd like to speak to you as the chair of the IPEN Toxic Fracking Working Group. IPEN is a global public interest network representing many hundreds of NGOs and community organisations across 100 countries, all committed to achieving a toxic-free future. And I'd like to highlight 3 important chemical issues of global concern related to the unconventional gas industry. Firstly, the international failure of the industry to adequately assess the chemicals used and released, the climate-induced impacts on the industry's waste practices, and finally, the role of unconventional gas in the manufacture of plastic and the resultant marine plastic wastes. We consider these 3 issues as seriously impacting on basic human rights, particularly our right to live in a pollution-free world. This right was acknowledged by the United Nations Human Rights Commission in 2001, and they established that the fundamental right to life is threatened by exposure to toxic chemicals, hazardous wastes, and contaminated drinking water. So first, the failure to adequately assess the chemical impacts. I'm sure many of you have heard governments from countries including the UK, US, Australia, New Zealand, South Africa, all regularly claim that the industry's fracking and drilling chemicals have all been fully assessed and government regulators know all the product constituents and all their impacts. This claim is naive at best and dishonest at worst. You may have heard in my earlier testimony of the significant failures of the Australian government's assessment of fracking chemicals. The situation is similar across all OECD countries. Much of the information on the potential environmental impacts of unconventional gas chemicals has still not been generated, and of what is available, much is protected under confidentiality regimes. Governments and industries have not evaluated the impacts of hydraulic fracturing mixtures, particularly their long-term effects, nor their interactions with each other or with the natural contaminants of the coal and shale seams. As it was put so well by one chemical regulator attending an OECD workshop for those responsible for the assessment of the industry's chemicals, and I quote, "We do not have adequate information to undertake even the most basic hazard and exposure assessment." A couple of years ago, when I was participating in a debate over access to information on fracking chemicals organised by the OECD, representatives of Halliburton, a major producer, as you know, of the industry's chemical products, repeatedly told the audience that the full information on product constituents would not be provided, as this was their confidential commercial business information. Commercial confidentiality regimes exist in all countries, and while they may vary according to domestic law, the overwhelming protection they give for the secrecy of product details appears universal. Nevertheless, we are aware that fracking and drilling products can include persistent bioaccumulative toxins, for example, fluorocarbon surfactants, brominated biocides, and chlorinated paraffins used in drilling. Fluorinated chemicals, often nicknamed the forever chemicals, are extremely persistent, and some simply never break down. These very persistent chemicals interact with each other and with the natural chemicals in coal and shale seams, forming a range of very toxic, persistent byproducts, some of which are recognized ozone depleters, for example, dichlorodifluoromethane or trichlorotrifluoromethane, which is often called Freon 1,1. It has some of the highest ozone depletion potential. Many of the Freon chemicals are already banned for use under the Montreal Protocol, but continue to be released unabated by the industry. We have measured them in flowback at the wellhead, and as you know, and as you've seen from Shay's presentation and Geraldine's, volatile and semi-volatile toxic compounds have been detected in the air, water, and urine of surrounding communities. There remain significant data gaps about the complete range of product constituents, their interactions, their environmental fate, their ecotoxicity, their long-term impact on human health and the environment, and hence any attempt at risk assessment for this industry is bound to fail, as it simply cannot evaluate the full impacts of the industry's toxic footprint. The impact of this on a child's right to clean water and to live in a pollution-free world are simply incalculable. Now, while most of you are aware of the impact the industry has on climate change through its considerable release of methane, few are aware that climate change also can impact on the industry's toxic footprint. Climate change is altering emissions to air of persistent pollutants by changing their rate of mobilization from materials, stockpiles, or even the wastewater ponds. The higher temperatures and changes in weather pattern are also remobilizing historical contaminants and altering their distribution through changes in long-range transport. Climate change impacts are altering the degradation, bioavailability, and even the toxicity of chemicals. For example, increases in water temperature have shown to increase the toxicity to aquatic species of commonly used chemicals, while changes in water acidity have been shown to affect the bioaccumulation of toxins in fish. Yet none of these impacts are being addressed by the unconventional gas industry or their regulators. The use of extensive holding ponds for wastewater, the burying of contaminated drilling wastes in situ, the creation of massive contaminated salt stockpiles, and the ongoing release of thousands of tons of volatile organic compounds into the atmosphere are all practices that will be affected by increasing climate change. For an industry generating significant amounts of chemical waste, which it currently is unable to manage, ongoing climate change represents some very serious challenges and some very serious risks. So finally, we are deeply concerned about the rapidly growing use of shale gas for the production of plastic and resultant plastic wastes. The impacts on vulnerable communities of the ever-increasing amounts of plastic waste contamination is simply devastating. Natural gas is now the primary source of chemicals for plastic production in both North America and in the Middle East. The ethane is used to make ethylene, which is a feedstock for polyethylene, for PVC, for PET, and polystyrene, while the propane is used to make propylene and ultimately polypropylene. The shale gas boom in the US has made these plastic feedstocks extremely cheap. driving investment and increasing production. The US industry is planning to invest over $164 billion by 2023, with many new ethane crackers designed and built specifically to produce ethylene from fracked ethane. With the overabundant supply of shale gas, analysts expect the production capacity and demand to increase by 1/3 in the next 5 years. This increased plastic production comes at a time when the global community has recognized the serious and in some cases irreversible impacts of plastic pollution across the world. Communities and countries are rapidly becoming aware of the devastating environmental degradation from plastics and their associated toxic chemicals. And as considerations for the new international treaty to address marine plastics progress, it has highlighted the human rights impacts on vulnerable populations, particularly those dependent on marine environment for their only source of protein. We believe the unconventional gas industry can no longer be allowed to remain silent about its part in this rapidly expanding catastrophe. So to conclude, we are only just beginning to understand the full implications of the toxic footprint of unconventional gas industry, and we can only hope that we are in time to respond effectively and to stop the industry's global pollution of our air, soil, and water. So thank you very much for listening.
Thank you very much, Marianne. That was excellent. I appreciate your input. What we'll do now is move straight into the presentation on the second subcase, which I will start the PowerPoint for now. This second subcase is on infrastructure. So this is our subcase and the evidence and the summary of our evidence that we'd like to provide the judges based on our second subcase, which is on infrastructure. My name's Shay Dougall. And the basis, our information and the evidence that we've provided in the testimony already identifies that the vast infrastructure and the way that it is pockmarked across the landscape, industrialising the rural amenity, has adverse physical and economic impacts on property and property values attributable to the activities and exposures associated with unconventional gas. So what are we talking about as far as infrastructure goes? Well, there is a starter list that is just a basic outline of some of the infrastructure, including the arbitrary lane over tenements, prefabricated cement, ponds, infill compressing, wastewater trucks. But anyway, this is a list that is much better told in pictures. So what you see here is that people are not given a consideration in the arbitrary application of the tenements. So when the government leases out whole sections of the country to multinational gas companies, they do so in arbitrary shapes like you see on this side of the screen. But on this side of the screen, what is underneath that is actually people's homes and the cadastral boundaries of their properties. So there's absolutely no consideration given from the get-go as to the people who are underneath this business deal that's been rolled across the landscape. This is a view of that same area, but with the overlaying the industry's infrastructure, the big parts of the infrastructure and their names. This is the view from, as a landholder who lives in that area, exactly what's going on there. What used to be basic mum and dads and farms is now scattered with country that is now owned by CSG companies and pockmarked by wells. Now, if we zoom even closer, you can see this is a very good model that's produced actually by Jazeera in their most recent report. And it's very useful in that it really clearly identifies the massive impact when we zoom in from a broad view down into the view from the ground, just what this industry does to one particular area. And if you look at that image, there's a vast impact from the sky to the air, to the ground, to the water, to the underground. It's absolutely intense. And the only thing missing from that image is the families. We zoom in even closer, and this is someone's property. This is an example of some other infrastructure. This is prefabricated cement roadway in what is supposed to be a farmer's grazing paddock. That previous picture is actually specifically taken from this image of what the industry has of that person's property. So the person who owned that property, this is how the industry sees his property. It's no longer his home, it's no longer his business. Now it's simply an industry's dash for gas. And this is someone's home. This is more infrastructure being installed. This is actually a public road. And this is another example of the government, of the industry, taking advantage of the entire area becoming their workplace, their lay-down yard. This is a public road. It used to be actually my kids' bus stop. Apparently on that day it didn't matter. This is an example of a multi-pad gas well. More infrastructure. This is an example of the types of things that are in people's backyard.
Argyle 22.
This is an example of the vents. The vents that are venting gas, uncontrolled, unmitigated, unrecorded, in people's backyards, in their businesses, more of the industry infrastructure. Then, of course, the infrastructure has leaks and spills, which we also need to deal with. And you can see the boundary fence on that particular piece of infrastructure isn't doing a lot to contain the leak. And then there's the impact that this infrastructure has on the night sky. And then, of course, there's the massive high voltage power lines that are installed for the sole and express use of the industry. It's not a public asset. And then there's all the trauma that goes into actually having those things rolled out across people's homes. And then there's the massive exporting facilities that they're wanting to roll up and down the coast of the entire country of Australia. And then, of course, once you take into account all of the industry's infrastructure, of course, the farmer's infrastructure is now no longer useful and is destroyed. This is a photo of a kicking gas bore, a kicking farmer's stock and domestic water bore that is now producing so much gas that the gas lifts what's left of the water. Basically, in this particular subcase, we address the framework principle number 8, where the government has actually, our evidence proves that the government has undertaken or authorised actions with environmental impacts that we've just shown you that interfere with the full enjoyment of human rights. The government has not required prior assessment of the possible environmental impacts of these projects and their policies, including their potential effect on the enjoyment of human rights. How could it possibly have been when you look at those images? Principle number 12, our evidence also shows that the government has not ensured that the effective enforcement of their own environmental standards are undertaken against public and private actors. That evidence also shows that under Principle 10, the government has not provided for access to effective remedies for violations of these human rights and domestic laws relating to the environment. So as this infrastructure is rolled out and as the impacts of that infrastructure is borne by the landholders, there is no remedy. So that is the end of our presentation on infrastructures, our subcase of infrastructure. And what I'll do now is just move on to the next presentation, if that's all right. Okay, so this third subcase that we've addressed, the evidence we've provided is based on the climate change and environmental impacts of the industry. So the environment climate change subcase is we address the principles 1, 11 and 16. And basically what we're talking about here is the scale of the industry. The scale of this industry and its footprint is, we talked about in that very first picture I showed you that shows the vast big business across Australia of this industry is it rolls the footprint of it rolling across groundwater dependent ecosystems, agricultural land, people's homes, it cannot ensure a safe, clean, healthy and sustainable environment. And it's anything but a precautionary approach that's been taken to this industry in Australia. The technology is novel, it's not yet standardised, it's poorly understood. There's uncertainty about the consequences, and what's worse is that the worst case potential for harm is enormous, and on the scale that it's planned, it's so large that cumulative impacts aren't even being part of the permitting process. So surely this is the very definition of human and earth rights impacts. The government has made these choices deliberately. They have decided to choose fossil fuels over renewables. They've chosen to create a gas industry. They've legislated that a portion of electricity must be made from gas. And the governments were so led by their desire of multinationals instead of the good of the country that they're dashed to create an export industry. They've destroyed the supply and demand basis completely for the product that they had previously legislated must be used. Exporting not only the gas, but where Australia's government is exporting the damage as well. So there is such a thing as Australian companies inflicting human rights impacts in this industry in other countries, in particular in Latin America. We have evidence provided to us from Latin America that shows a previous company in Australia who were responsible for the damage done to the Pilliga State Forest. That managing director is now in control of a company who's working in Uruguay, and they are undertaking this activity and putting at risk the major aquifer in Uruguay, which is one of the largest underground drinking water reserves in the world. So we're managing to export the damage as well, which is bringing into highlighting the issues associated with the guiding principles on business and human rights. The environmental impacts on large-scale developments come with an extensive catalogue of environmental impacts, and our evidence describes all of those impacts as you can be seen here. And the environmental impacts, the planned scale and the scope of the development in itself makes the whole question of impacts really complex. The projects are only licensed on a piecemeal method, but the cumulative impacts are not even potentially predicted, and they may even be worse than you could even imagine, given that the environmental systems are subject to this sort of disturbance on such a massive scale. Also, we've already identified in our evidence and in the first sub-case of health that the fugitive emissions of this industry, along with the ones that are actually acknowledged, doesn't mean that this proves that this industry does not wash up, as the spin indicates, as being cleaner than coal. The scientific literature tells us that people are already dying from climate change. So this is actually a legal and a moral question that climate change, this industry is contributing to, should it go ahead. Governments and industries are already being sued for their contribution to this. And we already know we have to leave at least the current, we cannot start opening up new areas of fossil fuel if we've got any hope at all of meeting our commitments in the Paris Agreement. We're supposed to love our neighbour. Australia's been called out by our neighbours for turning our back on those who will be the first affected by the impacts of climate change, who have been affected now. And here we are in this ever-expanding CSG industry. Then the climate change impacts also are attributable, in the evidence that we've provided shows that there is a current and increasing threat posed by these climate change conditions. That means that they will exceed the human capacity to deal with heat stress. And in Australia particularly, and in the Northern Territory particularly, we're looking at a situation where they are already very vulnerable to heat stress. Any changes in climate change will be a huge impact in that area. And yet, here it is, and our government has chosen just last month to raise the moratorium on fracking. So even if the government was to convince us that their concerns regarding climate change were meeting the community's concerns, and they referred us to their environmental impact statements as proof of the rigour with which the industry is held, well, they would still fail. Simone Marsh gave some extraordinary evidence to the tribunal regarding her submissions, identifying the lack of baseline data, lack of scientific rigour, star chamber protective behaviour undertaken within the government and the industry, all of which, of course, brings up the fatally false adaptive management mantra that the government hangs its hat on, that gives this industry permission to continue to be rolled out. But their environmental impact assessments address only individual projects, as I've already said. They're missing the cumulative impact. Also, ecologically speaking, our evidence also provided to the tribunal shows that these approvals were awarded to the industry without prior adequate knowledge of the ecological impacts on terrestrial, groundwater and marine environments. There's serious flow-on consequences to this. What we're saying is, what is it going to take for our government to hear? The government's continued response to anything that is raised as far as concerns in requiring them to have a response that is reasonable is continued denial and bloody-minded ignorance. So that's the end of that evidence load regarding the subcase number 3. There's only 2 more quick subcases left to go. So I'll move on now to the next subcase. It'll just take me a moment. And at the end of those 2 subcases, there's time for questions. So this subcase, this presentation is about the evidence we've provided the tribunal on the subcase about participation in government. In this case, we looked at principles number 4, 5, 7 and 9. Basically, that the government does not provide a safe and enabling environment in which we can operate free from threats, harassment, intimidation and violence in expressing our concerns for our human rights. The state, our government did not respect and protect the right to freedom of expression, peaceful assembly in relation to environmental matters. The government has not provided public access to environmental information by providing affordable, effective and timely access to information upon request. And the government has not provided for and facilitated public participation in decision-making related to the environment and the decision-making process of this industry. And taken from Benedict, the Australian human lawyers example, what they've described is really crystal clear. Our government is supposed to protect against human rights abuses within our country. This requires that they are to take adequate steps to prevent, investigate, punish and redress any abuses through effective policies, legislation, regulation and adjudication. This is a significant failure of the Australian government in relation to this industry. They have not ensured that our human rights are incorporated into the judicially enforceable legislation. They haven't backed that up with comprehensible implementation of policy. And that's enabled this CSG industry to manipulate the decision-making process and the outcomes in a manner that the basic human rights have been ignored. Also, their breaches are not subject to adequate corrective measures. And the importance and the impartiality and accountability in the management of this government's resources is really hard to overstate, particularly in this case. Mining licenses represent the largest transfer of assets from the public to private hands, where mining companies stand to gain hundreds of millions of dollars from any simple decision our government makes to allow mining and gas field to go ahead. And that happens with no public representation in that decision-making process. But we get to suffer through the negative economic impacts and on the non-mining industries, the communities and the environment. These impacts are devastating, and they're certainly not accounted for in any way that's appropriate, either by the legislation, by the government or by the industry. And this is what is at the heart of the fundamental failure of our government to us, its people. They have failed in their duty to protect and represent and facilitate public participation. They have deliberately and relentlessly pursued the creation of the gas industry, the removal of red and green tape, the rejection of anything about the precautionary approach, and they avoid investing in alternative energy. The evidence we've provided this tribunal has been available at every single level of the participatory process within our government. There's been legislative bias. We've provided evidence of the number of inquiries that we've had in this country, and that the outcomes have been clearly ignoring the will of the people. The lack of the right to say no, the lobbying and the revolving door. There's been regulatory failures. There's a devastating failure in the compensation arrangements. The right to information is awful as well. There's unconscionable conduct between the industry and the individuals. They fail to investigate incidents. They fail to adequately prepare for the industry potential emergencies in the community. And the burden of proof of having any impact rests with individuals and the anti-protest laws. The government inquiries I alluded to, you only have to look at the number of inquiries that have been held into this one industry across Australia and see the same outcome time and time again, and realise that the government is not listening to the people. You only need to read the government's own submissions to see the dismissive attitude that ministers and senators have on the issue of public opinion. This slide just shows in one simple view the number of inquiries that have been had. One of those particular inquiries was an inquiry into the bill for landholders in Australia to have a right to refuse gas and coal. This is a perfect example of the people requesting the right to protect our lands and our home if the government wasn't willing to do it. So the insulting result of that bill was an outrageously slippery manoeuvre on behalf of the committee responsible for that inquiry. They reneged on a technicality. They went to a lot of trouble to say that, yes, or we do support the principle that an agricultural landholder should have the right to determine who can enter and undertake gas mining on their property. But we see all sorts of problems with the details in the bill. So instead of coming up with recommendations or examples or fully participating in a meaningful, engaged discussion, the committee's report, the one and only recommendation was, we recommend that they don't pass the bill. The end. We provided evidence as well that the government has focused on this industry to the detriment of any alternative industry. And a really disturbing aspect of this lack of participation that we've provided evidence about has been the rampant and out of control cosy relationship that is between senior government representatives in not just the ministry, but also in the departments responsible for enforcing and the industry. It's completely at odds with the fundamental principle that all interested parties get to be treated equally in the decision making. There's been regulatory failures, and we've identified this in previous subcases. These projects are pushed through with broad regulatory tools, multiple land use frameworks, legislation, broad and lengthy and inconsistent conditioning, all of which means cumulative impact isn't considered and the public ultimately are prevented from participating in the decision making. Very specific evidence we have provided about the conduct and compensation agreement, which is a really significant abuse of human rights. The government licenses the industry to get the gas off of people's own private properties. These multinational companies access our private properties and put infrastructure in our place. The government refuses to give us permission to deny them access, forces us to the table to negotiate a compensation process that is constrained to a limited pool of a number of issues that certainly don't have any way close to representing the realities of what the real impacts are. The government forces individuals to deal with these multinational companies and sign the contracts giving access. The government gives each of these individuals no assistance. They leave them to enter into these long-term contracts with no information, no rights, and no data. But the government does draft a sample contract for use in this process. And of course, that sample contract is heavily biased in the favour of the multinational gas companies. The problem with this is, again, one of those framework principles is there should be fair and balanced approach to land use access and compensation. Well, we've provided evidence that requiring the contract to be signed does not mean that there's an agreement. There is a lack of requirement for the companies to disclose information that's really important to the individual expecting to live with it. The contract requires the individual to provide full disclosure about their plans for their own property. It lacks any helpful information to advise the individual about what types of additional conduct requirements that might be useful for them to demand from the company, which is again advantageous to the company. These contracts encourage confidentiality, which is not in the best interest of the individual, but certainly works with the company tactic of dividing communities. We provided evidence that shows that these contracts fail to even encourage basic contractual payment terms regarding implications of when the industry doesn't pay the individual. It places an undue burden on the landholder to protect the company's infrastructure, and it proves that the government knows about the poor insurance arrangements that exist and enshrines that poor arrangement into these contractual clauses. So basically, the right to information is non-existent. The landholder gets access to a handful of information that is industry-centric and propaganda, and that's prior to being expected to sign this long-term contract for access and impacts to your life and your property. And I'll show you on the next slide the type of documentation that you should really be requesting as an individual from these companies, just to begin to understand what the real impact to you and your property will be. And this suite of documents isn't listed anywhere. It's something that the individual is required to identify and specifically request. And then, of course, the company has to be relentlessly pursued to get that documentation. And of course, if you ever do get it, as a normal person, you then need to understand it. So here's your example of the framework principle requiring easy, prompt, effective, and practical access to information. We provide evidence that shows that while the gas company, this is one particular example, the gas company is pursuing a landholder, that I personally have dealt with this, for access and an alternative arrangement. The landholder requested a copy of the current plan of operations, any pre-clearance surveys, or environmental reports listing non-compliances, any emergency procedures. Very reasonable things: noise modelling, emissions modelling, risk assessments relating to the current contamination incident you have when you're not having a contamination incident, and the concurrent undertaking of CSG activities. And the response from the industry was, yeah, we don't consider it would be useful to get bogged down in reams of paperwork. So there you go. So say the landholder does sign this ridiculous contract. Well, an individual landholder is then required to undertake their own preparation to prove that there's been an impact in the future. Me, I'm supposed to go out and undertake my own noise surveys, atmospheric monitoring, water testing, weed auditing, overland flow assessments, all of this in order to establish my own baseline, in order to be able to prove there's been an impact in the future, which is, of course, prohibitive. And not to mention, important contributory data is the domain of the companies and stuff that I will never have access to. And when I do want to make a complaint, I have to make an approved complaint in order for it to be recorded or any action to be taken. We've provided evidence that the industry is dealing with individuals on whose land they're trying to access, but none of these arrangements consider the impact on neighbours. Alternative arrangements is another completely inconsistent issue in relation to human rights. an alternative arrangement isn't something that the government has permitted the industry to have access to, and effectively means that the industry, if they can get individuals to sign an alternative agreement, they don't need to comply with the legislated environmental authorities. So this is a really slippery slope, which enables the industry to breach, and those breaches to become the norm, and it's a loophole then for compliance in the future. And also, as far as the individual is concerned, again, if I don't sign a AAA, but everyone else around me does, I'm the last man standing. I'm a vexatious landholder because no one else is complaining. Of course, the anti-protest laws is another example of this government failing in protecting our human rights. So basically, to summarise this particular amount of evidence we've provided on this subcase, our government has failed us by not providing and actively avoiding the democratic and judicially supported process to have our rights considered and our concerns addressed, and the individual people at the coalface who are expected to host this industry are literally left on their own to navigate this gargantuan prospect of letting the industry into their home. So there's only one subcase that is left, and that is the subcase on culture. So it won't take very long either, the summary of our evidence provided there. At the end of that subcase, Benedict will complete his summary of our submission, and then there'll be some time for some questions. So this is our last presentation that summarises the evidence we've provided on the social and cultural impacts of this industry. In this framework, the framework principles we used in this subcase were the principles 3, 6, 13, 14 and 15. And effectively, the transformation of the rural landscape into an industrialised gas field profoundly changes the lives of the people who live here. The people threatened by or who suffer losses or injuries from gas field development, they're the ones who suffer the symptoms of emotional, economic distress and physical ill health. Those people, though, are not the multinational gas companies, their well-funded lobbyists, or the politicians or government departments responsible for this industry. The evidence we've provided, we gathered on our website, says it all. It speaks of the horrendous impact that this industry has had on the people. And this is but a small portion of the other thousands of similar stories happening across this land at kitchen tables everywhere, and some that I get phone calls about each week. This evidence is the stuff that never ever seems to be able to be heard over the thin and selfish rhetoric of the industry lobbyists and the government's greed. It's in things like the social impact assessment, and the only one that the government ever did in the 10 years of the industry. And in that one particular time they had the chance to do it, they made a conscious decision, as they wrote in their own report, not to meet with local landholders or community groups. What this impact in social and cultural is about, it's about booms and busts. And we've provided evidence of the impact that that has on communities. The social and cultural impacts include the traditional owners of this land, which is really important to note that the effective and genuinely representative involvement in the approval process of the traditional owners has not occurred, and this has a massive and direct impact on them. The social and cultural impacts include insurance impacts. Farmers can't get an insurance product to protect them against potential CSG impacts. And the industry won't insure the farmer either. Social and cultural issues are associated with the National Vendor Declaration, where the farmer is expected to assure a product that is supplied in an environment that he doesn't have 100% control over. The social and cultural issues and evidence that we've provided are about a change to the very fabric of our community. It's proved by movies that are made and songs that are written. This impact is shown by the evidence we provided of the water that bubbles with gas and is taken from the people. So, you know, the social and cultural impacts of this industry are also in the meetings that we are forced to hold as communities, the submissions that we make over and over again, the time that is stolen from being with our families. It's shown and in evidence by the entire change to lexicon that we now have in development of new terms such as fractivist, gas flu, that's what we call it when you feel sick in a gas field, gas hole, sacrifice zone, frackwit, glowworm, land and line officers, collateral damage, which interestingly was the term the industry used to describe us, ecocide, land spraying, intergenerational theft, eco-crime, gas field refugee, produced water, and coexistence, of course. The social impacts are also in the shocking use of the thin blue line by the government to try and contain the thin green line. And the documented effects on people living in close proximity to unconventional gas are multiple, and they're listed here and include all of the things that we've discussed and provided evidence for in our testimony. Distress-related concern to our health impacts, costs associated with environmental damage, increased stress, change to sleep patterns, impacts on health by noise, anxiety, social division, disempowerment, changes to community, increase in all of the demands, but certainly no increase in the infrastructure to cope with it. So basically, the summary of our evidence is that it shows that the unconventional gas industry is at the absolute coalface of the infringements on our basic rights, and the government fails at every turn to set the bar at a standard that even attempts to balance the perceived benefits from royalties and jobs against the obvious intrusion on basic and essential human rights and freedoms. As I was saying, the documented effects are there to be seen in our evidence. And our evidence shows that the unconventional gas industry is at the absolute coalface of the infringement on our basic rights. And the government fails at every turn to set the bar at a standard that even attempts to balance the perceived benefits of royalties and jobs against the obvious intrusion on our basic rights and the essential human rights and freedoms. So we have no rights and we have no remedies. So what is missing is an independent, impartial judiciary, good democratic institutions, and democratic processes that are in themselves the embodiment of these human rights. I want to thank Tom, Carly, and the steering group, and all of those behind the scenes, the Global Network for the Study of Human Rights and the Environment, Environment and Human Rights Advisory, Oregon State University and students in the master's degree, and the Spring Creek Project. And I want to thank the Permanent Peoples Tribunal and judges. Thank you for being the first institution in a decade that has listened to those of us impacted by this industry. I'd like to now hand over to Benedict Coyne to close our summary.
Thank you, Shay, for an incredibly comprehensive assessment and probably the most comprehensive assessment that we've seen in a decade as well. So thank you for all of your hard work on this, and I reiterate Shay's thanks to everyone who's made this possible. From all of the evidence provided in the 5 sub-cases that Shay has outlined, and Dr. McCarran's evidence and Dr. Lloyd Smith's evidence, and all of the evidence provided and available to the tribunal, it is very clear that the fracking industry in Australia and its destructive consequences has been enabled by a perfect storm of democratic dysfunction, comprising from the disproportionate political power of the energy lobby, left unregulated and unfettered, and the frail corruptibility of political regulation, as well as the lacuna of scientific evidence and baseline data. ongoing assessments and monitoring to demonstrate how harmful fracking is. As I stated before, fracking spotlights the glaring inadequacies of our centuries-old legal systems and has seen a remarkable phenomenon of corporate might with wanton disregard for our democratic foundations, plundering even the most sacred creeds of capitalism, being private property ownership and the common law right to the quiet enjoyment of your land without arbitrary interference of the state or any non-state actors. I thought I might also, just on that note, in terms of Australia, once again borrowing from the very tainted and stained law books of other jurisdictions and other more powerful jurisdictions, notably the US and the United Kingdom, and particularly in regards to policy, the industry's, I guess, emergence was ordained by George W. Bush's passage of the Energy Policy Act of 2005, which exempted fracking from the Safe Drinking Water Act of 1974 and the Clean Water Act of 1972. That was also colloquially known as the Halliburton loophole, and Dick Cheney was probably chuffed, although perhaps he should have been handcuffed. More recently, the UK government has even attempted to dilute the ancient law of trespass so companies can frack under people's homes without consent. And it seems again, and the reason I say that, because the international dimensions, notwithstanding Shay might be out near Chinchilla and out near Tara and out near all of those areas, make no mistake that the advent and rapid expansion of the destructive consequences of fracking is affecting democracy and human rights globally, and the solution needs to be found globally. And again, that's why we're so pleased and excited and honoured that the Permanent Peoples Tribunal has taken this opportunity to hear this petition. Now, the impacts, of course, are well known and have been provided evidence in all of the sub-cases. I especially Shay's incredible and comprehensive presentations and all the work that she's put in over the past many years, and looking at the health impacts in sub-case 1, infrastructure impacts sub-case 2, climate change environmental impacts sub-case 3, participation in government or lack thereof in sub-case 4, and social and cultural impacts in sub-case 5. Then Dr. McCarran's evidence and many years of research in the impacts, significant debilitating impacts on human health and those impacts on local communities, and especially the abject failures by government and the responsible authorities to assess, monitor, measure, and protect against the very adverse and sometimes unknown health impacts of all of the constituents and citizens and non-citizens of Australia, including, of course, the rights of children, the most vulnerable, the rights of women, of course, the rights of men, of course, the rights of people with disabilities, Indigenous people, and all of the noted consistently vulnerable populations or demographics that are noted consistently in international human rights law, and certainly in all those documents I outlined. We then, of course, heard from the amazing Dr. Lloyd Smith on her evidence about the toxic footprint of the industry in terms of its contributions to, I guess, end of pipeline pollutions, as well as in terms of plastics and creating a dirty, unsustainable, toxic international industry that whose products, as well as the byproducts, as well as the fugitive emissions, are just creating a very significant global time bomb of toxicity. And Dr. Lloyd Smith also discussed in detail, coming from an organisation that represents concerned communities in some 100 countries and academics and experts, about the air, soil and water contamination by the fracking industry, and of course the blood and urine contamination by this industry, and the most concerning evidence, of course, about the significant unknowns. the companies, these multinational companies, have not only turned democracy on its head, but they've actually turned the international architecture of international human rights law on its head in this sense, and even the common law at the heart of the Western liberal democratic legal system and the Judeo-Christian, philosophical model that underpins our legal system is this sacrosanct respect for private property of human beings and rights of human beings. You can look at the Ten Commandments, you can look at all the different, instruments that informed religions as I talk to, and the kind of distillations and developments and evolutions of them down to the present day and how they've informed everything and our kind of existential outlooks on planet Earth. Human rights have never been attributed to non-human entities, and I'm talking about corporations here. So it seems absolutely remarkable from Dr. Lloyd Smith's evidence, and particularly that anecdote about Halliburton talking about commercial in confidence, that the private rights of corporations are being prioritised very highly over that of human beings, when, even if broader human rights are not quite the foundation of our democratic systems, and even our modern kind of corporate capitalist systems, the fact that private rights of humans are being sacrificed for the private rights of corporations is hugely concerning, and again has that very very potent global impact. So universal fundamental human rights, including the right to a safe, clean, healthy and sustainable environment, whether expressed in national and international law or in national and subnational constitutions, are often insufficiently brought to bear or protected by standard state-based enforcement mechanisms. The failure of states to respect and enforce environment rights can open the door for intervention by non-state actors such as this tribunal. The decisions and actions by this tribunal, less influenced by the pressures of national politics and economic interests, can robustly articulate and stand up for the environmental human rights standards when states and international bodies fail to do so. And this session is replete with evidence as to that. In March 2016, the Sisters of Mercy delivered a joint statement with Australian landholders at the United Nations Human Rights Council, addressed to the UN Special Rapporteur on Human Rights and Environment, stating, quote, "From Australia to the US to Argentina, our communities report violations related to a safe, clean, healthy and sustainable environment." In late 2016, the UN Special Rapporteur on the situation of human rights defenders visited Australia and met with anti-fractivists and anti-frack campaigners and community members. I think it's important to note people aren't anti, people want to protect, they're pro-protecting their communities, they're pro-sustainability, they're pro-basic health rights. And they condemned the anti-protest legislation that Shay referred to, targeted at environmental activists, which would contravene Australia's international obligations. I think it's very important on the international context, our platform of international law, that the tribunal also consider and look further into, and I'm happy to provide supplementary submissions on this if required, the movement for a codification of the international crime of ecocide to be amended into the 1998 Rome Statute on the International Criminal Court. And that has been the subject of quite a big movement, in fact, little known about, not really made visible, perhaps a note for another petition to the Permanent Peoples Tribunal, who knows. But it's been considered for a long time by the UN, and it's been seen as very controversial, and it's kept disappearing and keeps kind of coming up and getting a gasp of breath. In September 2016, the International Criminal Court's chief prosecutor issued a policy paper widening the court's remit to focus on environmental crimes. Further action has been taken in the courtrooms of the world, but mostly gaining little fruit, as anthropocentric legal systems are increasingly proving impotent to the challenges of vast environmental destruction. I also think it's very important to bear in mind, whilst everything I say may be considered perhaps unnecessarily hyperbolic, or even hyperbolic. I'll withdraw that, and I'll state it as this. Even though the way that I describe what I see happening may be construed as hyperbolic, I would encourage the tribunal and the judges respectfully to really look beyond these seemingly innocuous pictures of little gas valves and invisible gas and things that you don't see, and pictures of the countryside and cross-woven tapestries of gas wells that I think to some eyes, and certainly some non-expert eyes and layperson's eyes, may seem innocuous. But the reality is this is a proven deadly industry, and it's important that, and I'll say, even though I'm a slam poet in my other life, and I perhaps have some tendencies to go into the hyperbolic, I would encourage the tribunal to look at a strict conservative black letter reading of international human rights law and even domestic law, which doesn't even engage international human rights law in Queensland or Australia in many ways. And that in and of itself, even in the strictest, most conservative black letter reading of the law, all of the subcases evidence flagrant breaches of the rule of law and of democratic principles. So in that regard, the movement against the fracking industry represents a veritable final frontier fight to save the integrity of our democracies from the clutches of unregulated corporate power. One could perhaps describe it as a lawless lacuna or a gasland Guantanamo, where the dismissive attitudes of politicians and government representatives that Shay described have really put us in this no person's land of lawlessness. The rule of law doesn't seem to need to be considered. They have all of these kind of pantomime inquiries after the fact usually, and thankfully in some of the states and territories we've had success in those upholding those moratoriums, but those moratoriums are very, very fragile and very delicately in place. So, I mean, it may even be the case, and it's always easy to look back on history as we learn from history, that the governments have already sold our democracy to the highest bidder and lost control. It certainly seems like that from the evidence. And if that is the case, then it's time to put all of this evidence on the record, which is why we're here. And it's time for people, community members, community advocates, everyone to wrest back control. We've all heard the term and the adage, power corrupts, absolute power corrupts, absolutely. As much as we might want to love and trust all of our political representatives, unfortunately it is a well-established historical fact that concentrations of power in a ruling elite without regulation tends to result in corruption, nepotism and human rights violations, even in Australia and Queensland, as detailed in the evidence provided. Politics, it has been said, is, quote, the arena where conscience and power meet and will be meeting until the end of time. However, it has been noted that, quote, conscience so often fares poorly in such encounters that we celebrate the occasions where power gives more than its tip of the hat, such as drafting and the adoption of the Universal Declaration of Human Rights and all of the international human rights laws that have emanated from there. While it's easy to be cynical and dismissive of the UN as not having any teeth or not being able to encourage and influence governments, I think it's important to note that even having that consensus, there were 48 nations that adopted the Declaration of Human Rights in 1948, and there were 56 nations in the, quote, international community at the time, 8 abstentions, no one voted against. Fast forward many years to 1993, and the Vienna Conference on Human Rights passed the Vienna Declaration Programme of Action, which was endorsed by over 170 nations, reaffirming the principles of the Universal Declaration of Human Rights. So there's absolutely this kind of very very stark duality between the aspirations of humankind for a better world and then the kind of vulnerabilities of human nature to greed and corruption and those kinds of things. So democracy is not a static state. It is a continuum of socio-political interaction requiring constant vigilance by civil society to ensure that the lines of acceptable civil power are properly and responsibly held and discharged by the executive, legislative and judicial arms of government. Human rights are exactly the same. Rights exist and arise infinitely and naturally in every human being by virtue of being human. However, in the words of our former Federal Attorney General George Brandis, quote, "I do not think rights are conferred by the state. I think rights need to be protected by the state, but they are not conferred by the state," end quote. This is why it is so crucial that human rights be legally protected and enforceable through the courts in Queensland, Australia and around the world. Laws are implemented to create standards by which we judge and regulate our own behaviour and that of others. Behaviour that we consider as socially acceptable and in the best interests of not only one another, but also our children and future generations. The current gaping deficit in regulating fracking is the consequence of a significant lack of political will to act in our best interests. What Australia urgently needs is a Human Rights Act framework at both federal and state levels to be implemented and utilised as a legislative framework through which we implement laws that regulate fracking, as well as enhancing existing laws for environmental impact assessments, health assessments, socio-cultural assessments, etc., etc. Laws that will properly protect the rights of citizens from arbitrary interference by the state and private corporations, and laws that will proactively protect the integrity of our democracy, the rule of law, our environment, and the rights of future generations. And I will re-quote Shay here because I think this is a particularly powerful summary of our position to the tribunal. Quote, "We have no rights and no remedies. We need an independent, impartial judiciary, good democratic institutions, and democratic processes that are themselves the embodiment of various rights," end quote. Now, in closing, I want to come to giving our submissions on what we want the tribunal to do and our recommendations to the tribunal in its considerations and formulating its advisory opinion on the 4 central questions to this petition. I also want to preface that I would, and we would, really encourage the tribunal that when it comes to its deliberations to consider whether, or at least to consider the efficacy and utility in sending those recommendations to the Prime Minister of Australia, to the Opposition Minister of Australia, to the Minister for Environment and Energy of Australia, to the Queensland Premier, to the Environmental Minister of Queensland, Leanne Enoch, to the media, to all premiers in Australia, including those who have up until now done the right thing and maintained a moratorium, and to all environmental ministers throughout Australia, because I think it will have a huge impact. And I think, and I know from my interactions with politicians, that if they have something to grab hold of to justify a conscious and conscientious moral and legal position, such as the consensus of an international tribunal, that will really help and assist the advocacy in Australia. So, number one, we would respectfully request a declaration that the human rights dimensions of fracking consider a number of risks, impacts and contentious issues related to fracking activities, and that all of that should be weighed before allowing any hydraulic fracturing operation to go forward. Apologies, that was not particularly articulate, but in terms of enhancing preliminary assessments to assess the human rights dimensions of fracking. Number two, a declaration that the human rights of numerous and various landholders have been violated by the Australian government, the Queensland government and private companies, as detailed in the case studies outlined. Number three, that without delay and as expeditiously as possible, the Australian government urgently introduce a Federal Human Rights Act, which includes express rights to the enjoyment of a safe, clean, healthy and sustainable environment in adherence to the 2018 Framework Principles on Human Rights and the Environment. Number two, a national plan of action for the 2011 United Nations Guiding Principles on Business and Human Rights, which includes specific provisions for fracking companies and their interactions with landholders, the rights of landholders against private companies and the state, including with regards to access to information and access to justice. Number 4, that without delay and as expeditiously as possible, a recommendation that every state and territory government throughout Australia urgently introduce a Human Rights Act or Human Rights Framework, which includes express rights for the enjoyment of a safe, clean, healthy and sustainable environment in adherence with the framework principles. Number 5, that without delay and as expeditiously as possible, the Australian government and every state and territory government implement the 2018 framework principles on human rights and the environment, especially and specifically all of the principles referred to in the case studies by Shay's submissions. Framework Principle 2, states should respect, protect and fulfil human rights in order to ensure a safe, clean, healthy and sustainable environment. Framework Principle 3, states should prohibit discrimination, ensure equal and effective protection against discrimination in relation to the enjoyment of a safe, clean, healthy and sustainable environment. Framework Principle 5, states should respect and protect the rights to freedom of expression, association and peaceful assembly in relation to environmental matters. Framework Principle 8, to avoid undertaking or authorising actions with environmental impacts that interfere with the full enjoyment of human rights. States should require the prior assessment of the possible environmental impacts of proposed projects and policies, including their potential effects on the enjoyment of human rights. And I just want to pick up a couple of lines from the commentary of Framework Principle 8, especially with regards to business enterprises should conduct human rights impact assessments in accordance with guiding principles on business and human rights, which provide that businesses, quote, should identify and assess any actual or potential adverse human rights impacts with which they may be involved either through their own activities or as a result of their business relationships, include, quote, meaningful consultation with potentially affected groups and other relevant stakeholders, end quote, integrate the findings from their impact assessments across relevant internal functions and processes and take appropriate action. And that is referable to guiding principles 18 and 19 of the guiding principles on business and human rights. And I think actually a separate recommendation that the tribunal recommend that all business enterprises in Australia must conduct human rights impacts assessments, including with the guiding principles on business and human rights, where those companies are in any way involved in the fracking industry or the supply chains of the fracking industry. Framework Principle 9, states should provide for and facilitate public participation in decision-making related to the environment and take the views of the public into account in the decision-making process. Framework Principle 10, states should provide for access to effective remedies for violations of human rights and domestic laws relating to the environment. Framework Principle 12, 1 and 12, Shay also mentioned. Obviously, we cover the field. We want all the framework principles, but I'm just picking out ones that are particularly relevant. And Framework Principle 14 is in relation to vulnerable peoples, including children, women, people with disability, Indigenous peoples, etc. And I would particularly like to give an acknowledgement and a shout out to a former client of mine, John Jenkin, and his family. He had 2 children with disability who unfortunately were stuck right in the heart of the gas industry and all of its toxic pollution for about a decade before finally being able to move. Moving on to the 6th recommendation, that without delay and expeditiously as possible, the Federal Australian Government urgently implement all the outstanding recommendations of UN treaty bodies and special rapporteurs, including, but not limited to the following: the Human Rights Committee, the Committee on Economic, Social and Cultural Rights, the Committee on the Elimination of Discrimination Against Women, the Committee Against Torture, the Committee on the Elimination of Racial Discrimination, the Committee on the Rights of the Child, the Committee on Rights of Persons with Disabilities, the UN Special Rapporteur on Indigenous Peoples, the UN Special Rapporteur on Health, the UN Special Rapporteur on the Situation of Human Rights Defenders. And I would specifically ask the Tribunal to consider making that declaration with regards to all of the recommendations that the Special Rapporteur on the Situation of Human Rights Defenders made in his report on his country visit to Australia earlier earlier this year. I won't read through them all now because I'm probably on time. But I think that is all. Thank you very much, everyone, and I look forward to watching the remainder of the tribunal. Thank you.
Thank you. Thanks. Any questions, Gil?
Well, that was absolutely wonderful presentation. I've read the 33-page document, actually 34, but there's nothing much on the 34th. What bothers me is how do I get hold of all the information that I've been exposed to now, particularly since I apparently was the only judge able to make this session. I like to work with hard copies. So I mean, it was just overwhelming, you know, the work that's gone into it was so impressive. I mean, I've sat on a lot of tribunals and this was, you know, tops. So that, yeah, I mean, that's my basic question. I mean, I've got some other questions, but I mean, there's so much there. That,
okay, so you're asking for access to hard copies of the evidence. I mean, we've got all of the evidence we've provided is hosted on the website. Yeah,
the evidence, I have this website, although it seems to be different every time somebody mentions the website, they give a different name to it. But anyway.
No, it's our website.
On the front of yours.
Yeah.
On the front of yours, yeah, I have that. But evidence is fine, and we need that. A lot of it is similar to what we heard from the Ohio folks, and probably will from Charlottesville, but different but similar.
Yeah.
But there's just so much in the PowerPoint presentations, and in Ben's 2 submissions.
I can give you hard copies of that.
If I want to sit down with the rest of the judges and discuss these matters, we need that kind of information as well as the evidence. So it's kind of the fact with analysis and recommendations that we need.
So do you want me to email you copies of those presentations, which I can do?
Yeah.
Yeah, would that fulfill your need? And Bennett can send you his.
He's already agreed. I chatted with him a little bit.
Okay. So I'm more than happy to send you those PowerPoint presentations.
Okay.
And anything else that you need, I can send. Yeah.
Yeah.
Is that what you need?
Yeah.
No worries. Absolutely. Actually, I've already made sure that Emily Grubby has copies of all of them.
Okay. So.
But I will include you. I'll ask Emily how to go about making sure you have access to that data.
Yeah.
I'll make sure, or I can just give you access to a Dropbox or whatever.
Well, I need it by email with it.
Okay, all right, email. I can email you. See, they're quite big. I'll upload them to the website.
But if you email, if you share the Dropbox, it'll go to it'll go to your email, Gil, and you can just press on it. And going to Dropbox is the same as going to an email address. It's it's effectively the same. You might have to set up a Dropbox, but it's just like setting up an email.
I'll just post it on the website.
Yeah. Just the least involvement with technology, the better, as far as I'm concerned.
No, I agree.
No worries. I will deal with that.
We'll send it by carrier pigeon from Chinchilla.
I'll get that organised, Gil. No worries. Did you have any other questions?
Well, one was a very simple one. Who were the 2 people who in 1932 prophesied all of this?
Burl and shit, I can't remember
If you have a reference, send it to me.
Yeah, I will. I'll send you the reference. No worries.
Of course, Karl Marx predicted most of what's happening today, even before 1932.
Yeah.
The other thing, I'm not exactly sure what the context was, but and this is just a comment, and you know, with respect, as we say, it's not a criticism really, but lately I've been thinking about the use of the word shareholders, and I've seen some commentary about that, and it seems to me that that's a very benign way of referring to corporate capital, and you know, what is good for the shareholders, and you know, we're all shareholders, you know, it's good for the country, blah blah blah, but in fact, not all shareholders are equal. And we know that there's a small group that dominate corporate capital. And the corporate, you know, shareholders, many of them are very nice, some of my best friends. But the corporations, as you've demonstrated, are not very nice. And those who control the corporations are shareholders, but they're the ones who have most of the shares. So just as a kind of ideological a suggestion about, you know, educating the public, as we're all trying to do, I think we need to be careful of that word and how we use it. You know?
Sure.
Because it kind of disguises what's really going on.
Yeah, absolutely. I get you.
It's too fuzzy and warm towards the real shareholders.
Got you. I got you. Thank you for that feedback.
Yeah, sure. Okay. I'm going to bed now. I've been up since about 10 hours ago.
So sorry, and I so apologize for the technical difficulties, but Gil, thank you so much for being here and lending us your ears.
Thank you, Gil.
Thank you.
Everyone. Brilliant.